Hey everyone, welcome to my channel. In today's video, we are going to continue our discussion on the Patent Amendment Rules 2024. So this is the second part of the video. The first part has already been published on YouTube. If you have not seen that, I will tag it somewhere here. You can just click on it and watch it. Having said that, let's start with the topic. Alright, so the first amendment has been made in Rule 55, that is pre-grant opposition. This new set of rules has further defined the steps to be followed when a pre-grant opposition is filed. So earlier what used to happen, that is, before this new set of rules came into existence, whenever a pre-grant opposition was filed by an opponent, the controller would review the pre-grant opposition, then the controller would notify the applicant about the same, and then the applicant would file a response to the pre-grant opposition. Then a hearing would take place and eventually the controller would give the final decision, like whether the patent application needs to be refused or whether the patent application needs to be amended, something like that. But now what has happened is, if the controller receives a pre-grant opposition, the controller reviews it, and prima facie, that is, once the controller reviews it, the controller feels that, the pre-grant opposition does not have that much value. In that case, the controller has the power to refuse the pre-grant opposition and give the reasons of refusal within 1 month of such a notification to the opponent. Right? So earlier this was not possible. Earlier, whenever a pre-grant opposition was received by the controller had to take that forward. But now the controller has the power to refuse the pre-grant opposition if the controller prima facie feels that the pre-grant opposition does not have that much of value. So let's just once go through this statement. So if no prima facie case of opposition is made out in a pre-grant opposition, that is, the controller feels that there is not much ground in the pre-grant opposition which has been filed by the opponent. In that case, the controller can directly refuse the pre-grant opposition and record the reasons of refusal within 1 month of such refusal. So the controller has the power to refuse the pre-grant opposition and then give the reasons for refusal within 1 month of such a refusal. Alright, so now if let's say the controller refuses a pre-grant opposition, then what happens? In that case, the opponent has an opportunity to request a hearing with the controller, wherein the opponent can justify the reasons why the opponent has filed such a pre-grant opposition. After such a hearing, if the controller still feels that the pre-grant opposition does not have that much value, then the controller can still refuse the pre-grant opposition. Or otherwise, if the controller feels that the reasons which is provided by the opponent justifies the filing of a pre-grant opposition, in that case the controller can accept the pre-grant opposition. So whatever the case, whether the pre-grant opposition is refused or accepted, within 1 month of the hearing, the controller has to pass an order indicating whether the pre-grant opposition has been accepted or refused. So let's just go through the statement once. If the opponent requests a hearing, then the controller will provide the opponent the opportunity of being heard and then pass an order to refuse or accept the pre-grant opposition within 1 month of hearing. Alright, so now if we consider the alternate scenario where the controller receives the pre-grant opposition and after reviewing the pre-grant opposition, the controller feels that it has value. In that case, the controller accepts the pre-grant opposition and notifies the applicant within 1 month of receiving such a pre-grant opposition. So let's just go through this statement. If prima facie a case is made out, the order for acceptance of the pre-grant opposition and notification to the applicant must be issued within 1 month of receiving the pre-grant opposition. Alright, so this is the scenario where the controller reviews and feels that the pre-grant opposition has value and it should be accepted. So in that case, the controller will notify the applicant about the same within 1 month of receiving the pre-grant opposition. Alright, so the next amendment in Rule 55 is made for the applicant. So in the previous rule, what used to happen was that whenever a pre-grant opposition was filed by an opponent, the applicant had to file a reply statement to such a pre-grant opposition within 3 months from the notice of opposition from the Indian Patent Office or the controller. So this was the time period which was given to the patent applicant to reply to the pre-grant opposition. But now, as per the new rule, this timeline has been reduced from 3 months to 2 months. So now the patent applicant has only 2 months to file a reply statement to the pre-grant opposition. So this has been done to conclude the opposition matter as soon as possible. The next amendment that has been made in Rule 55 is that earlier there was no fee required to file a pre-grant opposition, but now as per the new rule, fee has been brought in if an opponent wants to file a pre-grant opposition. So this has been done because in some cases the opponents would file a pre-grant opposition just to delay the process of getting a patent grant. So in order to avoid that from happening, now fee has been brought in. So this will reduce the number of pre-grant oppositions that are filed in the Indian Patent Office. So if you see now, the fee has been introduced for filing pre-grant opposition, and the fees are like 4,000 for small entities, startups, education institutions, and 20,000 for large entities such as large corporates. And one more rule that has been brought in now in the pre-grant opposition is that the patent application in which a pre-grant opposition is filed now will be considered as per the Rule 24C. So the prosecution of the patent application in which a pre-grant opposition has been filed will get fast-tracked. So instead of following the Rule 24B process, which is a slightly longer version in compared to the Rule 24C, so 24C will be followed so that the prosecution of the patent application will get faster. So the next amendment is in Rule 56, that is post-grant opposition. So the previous rule was that the opposition board was supposed to provide its report to the controller within 3 months from the date on which the documents were shared with them, right? So you might know that the difference between pre-grant opposition and post-grant opposition is that an opposition board is constituted in the case of a post-grant opposition, who reviews the entire matter and gives the recommendation to the controller, whether they feel that the post-grant opposition matters or not. So earlier the timeline which was given to the opposition board was 3 months to submit whatever their recommendation was to the controller. But now, in order to fast track the process of concluding the post-grant opposition, this timeline has been reduced to 2 months. So now the opposition board has a timeline of 2 months to share their recommendation to the controller or the patent office. The next amendment is in Rule 13, that is divisional applications. So a new sub-rule has been added in Rule 13. So earlier there was slight confusion with the divisional applications, but now a new sub-rule has been added which clearly states that any number of divisional applications can be filed for distinct subject matter disclosed in a corresponding provisional specification, complete specification, or previously filed divisional application. Right, so this sub-rule has been added just to clarify the Rule 13, and now there is no limit to the number of divisional applications one can file. So an applicant can file multiple divisional applications if distinct subject matter is available in the already filed provisional, complete, or a previously filed divisional application as well. The next amendment that has been made is in Rule 137, that is powers of controller. So this rule is regarding the petitions which were filed by the applicant when the applicant would cause some irregularity or delay in filing certain forms which were required to be filed by the Indian Patent Office. So earlier there was an option of filing a petition to correct so and so case, but now certain cases has been excluded which were earlier allowed by filing a petition under Rule 137. So let's just go through those cases which has been excluded. So the first one is submission of Form 3. So earlier if an applicant would miss filing a Form 3 within 6 months of filing a corresponding application, then in that case they could file a petition and correct that scenario. But now this has been removed. But an extension has been allowed by filing Form 4, so which could be extended for a period of 3 months. Then a filing of national phase application which needs to be done within 31 months of the priority application. This has also been removed from the petition under Rule 137. Then filing of English translation of PCT application. Then filing of priority document. Filing request for examination. Filing FER response. Extension is already allowed by filing Form 4. So 3 months extension is already in place which could be used by the applicant if they are getting delayed in submitting FER response. But this has been, now excluded from the petition under Rule 137. Then filing reply statement in case of pre-grant opposition. So we just, read about this new amendment in pre-grant opposition, which is the timeline has been reduced to 2 months from 3 months. Then filing renewal fees. So extension is already there by filing Form 4. Then filing review petition. So in case you want to set aside a controller's decision or order, you would file a filing review petition. So now this has also been excluded from the Rule 137, but extension is already allowed by filing Form 4. Then filing working statement. So there has already been made certain amendments in filing working statement, which we discussed in the first part of the video. With reference to that, this has been removed from the Rule 137, and now extension is already allowed by filing Form 4. So these are certain cases which has been excluded, which would earlier corrected by filing, petition under Rule 137. So they are no longer allowed in this certain rule. Then this is the last amendment which we are going to discuss, which is Rule 138, powers to extend time. So previously an extension of 1 month was allowed for some cases under Rule 138, but now what has happened is, as per the new rule, extension of 6 months is allowed by filing Form 4. Okay. Then Form 4 can be filed for any number of times before the expiry of 6 months. So this has also been added in the new set of rules. And then the most important rule with respect to 138 is the fees. The fees has been increased quite a lot. So earlier the fees for filing a petition under Rule 138 was quite lesser compared to what the new rule suggests. So as per the new rule, if someone had to file a petition under Rule 138, they will have to file 10,000 rupees if they are an individual, small entity, startup or an educational institution. But if they are a large entity, in that case, they will have to file 50,000 for each petition. So this is a very big change in terms of fees in case of Rule 138. So that was it in the topic of Patent Amendment Rules 2024. I hope you would have seen both the first part and the second part. We'll meet again to discuss more on patents in the next video. Thank you so much.